Good evening, everybody. Particularly at the outset, I would like to thank Bar Council of Maharashtra and Goa office bearers and my friend Dr. Uday Varunjikar for giving me once more. Last week I was there before you, and now once again I have been invited. Today I'm going to speak to you on the topic mediation under Consumer Protection Act 2019, and also we are going to deal with e-commerce rules under the CPA 2019. Actually, these two topics are separate and different and not interrelated in any way, but these are the two topics which are going to be covered under the CPA for which you are now going to appear for the exams. And from that angle, we are going to see what this mediation provision is, what are the e-commerce rules. In my last lecture, as I said, that was the new provision. What I talked about, that was the Central Consumer Protection Authority. Even happily now also today I am given a topic which is again a new introduction in the Consumer Protection Act. This is a mediation. Now I will divide this into two parts today's lecture. First I will deal with the mediation and then I come to the e-commerce rules. Now friends, it seems very odd, I would say, as a consumer activist, I would look at it as odd that the Consumer Protection Act, be that 1986 Act or be that recent one, that is 2019 Act, we all know that this Act provides for a dispute resolution or dispute redressal mechanism, which is mandated or at least expected to redress the consumer disputes within a span of 90 days to 150 days. Now, if the law itself creates a dispute resolution mechanism, which is supposed to dispose of the complaints within 3 to 5 months, what is the wisdom and what is the need for providing that act itself with an additional provision of a mediation? Because mediation itself, as many of you may be aware, is one of the alternative dispute redressal mechanism or dispute resolution mechanism, I would say, to be very precise and particular. It's an alternative dispute resolution mechanism. Now, why so? In a way, is it not an admission that all said and done, and with all our best efforts from the government, from the consumer commissions and all, is it in a way indirect admission that your disputes are not going to be resolved within 3 to 5 months as the law provides, and hence this bypass is given by way of a mediation? Whatever be that, but since this separate chapter is provided under the new CPA 2019, and that is chapter 5, it comes after chapter 4, which is about the dispute redressal mechanism. As you know, district commission, state commission, and national commission. And after that is a chapter which is on mediation. This chapter has sections from 74 to 81. Now, before that, before we go into section 74 to 81, there is another section, which is section 37, which actually gives rise to the mediation under this act. And if you see this provision particularly, reference to mediation, section 37 says that at the first hearing of the complaint, after the admission or at any later stage, if it appears to the district commission that there exists an element of settlement which may be acceptable to the parties, in each such case, the commission may direct the parties to give in writing within 5 days consent to have their disputes settled by mediation in accordance with the provisions of chapter 5. That is chapter 5, as I said, is a chapter for mediation. Now there are two words which are significant. This section 37 says that the commission will direct. In such cases, commission may direct to give the consent. Now, consent itself is being directed. Normally, we mean consent means it's a voluntary consent. Nobody can force me. But here it is a direction coming from the bench. Mind you, section 37 has to be read very carefully. So the discretion is given to the commission that if the commission feels at the time of admission or even at a later stage in a second hearing, third hearing, or at whatever stage, that, hey, this is the matter which can be resolved amicably. In this case, the commission has been given a power under section 37 to direct the parties to give consent for this. So once that is there, then the matter goes into chapter 5, which is section 74 to 81, and then the things will start. But before that, just let me say, what is this ADR? This is the mediation is a part of the alternative dispute resolution mechanism, as I was saying. Why alternative dispute resolution? Why not the traditional dispute resolution? The things are very clear, simple, because as everybody knows, Indian judicial system is totally bogged down with numerous cases, and because of which there are long delays in disposal of the cases. Be them the civil courts, be them criminal courts, be them the consumer courts, you go everywhere, there is a delay and delay and delay. And that is why there is a need for alternative dispute resolution mechanism. And this is not only typical or peculiar to India. All over the world, today this ADR mechanism is gaining popularity because it has certain very concrete advantages for the parties, both the parties. And that is why number of governments in the world are today encouraging ADR mechanism for dispute resolution among the parties. Now, in ADR mechanism, what are the alternative dispute resolutions mechanisms? One is known as a arbitration, the other is a conciliation, and the third one is a mediation. Now, many of you being the advocates, you must be familiar that there is an Arbitration and Conciliation Act 1996. And earlier there was another act which was replaced by the 1996 Act. So arbitration by way of ADR or conciliation by way of ADR has got a legal framework. What about the mediation? For mediation, today we do not have any legal framework as such. Although there is a section 89 in CPC, which provides for all these things, that if the judge finds that there is again an element of settlement before the parties, then it can suggest to go for the arbitration or mediation or conciliation. But for mediation, there is no separate law like the Arbitration and Conciliation Act. But at the same time, all of you must know that there is already a bill before the parliament, which is called a mediation bill. It was referred to the parliamentary committee, and parliamentary committee has again sent back that to the parliament with certain recommendations and all certain changes in that. And it's a matter of time that sooner or later, we are going to have also the Mediation Act. Why I'm saying this? Because now under the Consumer Protection Act, we have a mediation chapter. So it has all the, I would say, the sanctity of law, and tomorrow is going to also have a mediation bill. So more concrete provisions will be there with regard to the mediation. But as far as disputes under the Consumer Protection Act are concerned, what we need to see is what matters can be referred to the mediation. Before that, as I said in section 37, if the commission finds that there is an element of settlement, they can direct the parties, why don't you take a chance? And now, Under the mediation chapter, I must share this, that apart from section 74 to 81, the government has also made rules, mediation rules under the CPA, which you must read. And further down, the government has also made the regulations under mediation chapter. In fact, these regulations are more elaborate, and some of them I will touch upon during this short time, whichever are relevant. So now we have section 37 under CPA dealing with providing for the mediation. Then we have entire chapter 5, 74 to 81, which is elaborating the process of mediation. And then there are mediation rules and then mediation regulations. Now let's see what this section says. Section says that section 74 says establishment of a consumer mediation cell. Now it is made mandatory that each district commission, whether it is a district commission in any state, any country, or state commission in any state, and even the national commission, each commission under the CPA shall have a mediation cell attached to it. And it's the responsibility of the commission's president to see that there is a panel of mediators. Section 74 and then section 75. 75 says empanelment of mediators. And they are supposed to advertise, and I think the state of Maharashtra, State Commission has already empaneled the mediators. We will see who are all eligible for that. And then the nomination of the mediation panel. I will not go into that. Replacement in certain cases, I will not go into that. But what is more important is the procedure and the settlement. What does it say about the procedure? Section 79 deals with the procedure for mediation, and it says that the mediation shall be held in the consumer mediation cell attached to the district commission, state commission, or the national commission, and shall, while deciding the mediation, they shall have regard to the rights and obligations of the parties, usage of trade, if any, and the circumstances giving rise to the consumer dispute, and such other relevant factors. Now here, I will pause for a moment and take you to the entity called a mediator. Who is this mediator? Now, mediator is supposed to be a third party, not interested in your dispute, who's called upon to mediate. Now, what is mediate? And that reminds me that since your examination is also going to be partly in Marathi and partly in English, I will also, like last time, deal with these provisions and my lecture partly in Marathi and English. तर थोडक्यात हे मध्यस्थीचं काम आहे. मीडिएशन मीन मध्यस्थी. ही एक त्रयस्थ मध्यस्थी असते, थर्ड पार्टी मीडिएटर, आणि त्यांना हे मॅटर दिलं जातं. पॅनल आपण तयार केलेलं आहे. प्रत्येक डिस्ट्रिक्ट कमिशन, स्टेट कमिशन, नॅशनल कमिशनला पॅनल ऑफ मीडिएटर्स असणार आहे, अँड द मॅटर विल बी रिफर्ड टू द मीडिएटर. आता त्याच्यात असं म्हटलेलं आहे रेग्युलेशन्स मध्ये की द मॅटर विल बी रिफर्ड विदिन 5 days. पहिल्यांदा when the commission directs the parties, within 5 days, both the parties are required to give their consent in writing to the commission that yes, we will agree for this sort of a mediation. त्याच्यानंतर 5 दिवसात the commission is supposed to appoint the mediator from the panel. आता मगाशी आपण म्हटलं त्याप्रमाणे who will be the mediators? Mediatorsची जी एलिजिबिलिटी दिलेली आहे, there is a again in that there is a regulations. In that regulations मध्ये असं म्हटलेलं आहे की retired judges of Supreme Court, High Court, then retired members of a consumer commission, these are all eligible to be considered or empaneled as a mediator. Then retired district judge, retired judicial officers, an advocate with a minimum experience of 10 years, and also a person having experience of at least 5 years in mediation or conciliation, and experts or other professionals with at least 15 years experience in that particular field. So apart from the retired judges and also advocates having more than 10 years practice, even the professional mediators, those who have undergone this 40 hours course as prescribed by the Supreme Court, they can also be appointed as mediators, because mediation is a skill. And there are professional mediators who know how to make the parties talk, resolve their disputes, dissolve their egos on the parties' egos, because many a time the disputing parties, they have a lot of egos, and that is what actually prevents the resolution of a dispute. And these professional mediators are skillful mediators who try to separate the ego from the real issues in the dispute. So it's a very challenging task of making the warring parties come together on the discussion table and try to resolve the thing. So once this mediator is appointed, the matter goes before the mediation now. And it will come out of the Consumer Commission, but it will go before the mediator. Now, mediator has been given a time as per the regulation, maximum period of 3 months. After 3 months, the mediation shall stand terminated unless extended by the commission, when the mediator may perhaps refer back saying that there are still chances, but with discussions are going on, or some because of some reasons it could not be completed within 3 months, then extension is possible. But normally the mediation is expected to be completed within 3 months after it is referred to this. Then the regulations also deal with the code of conduct for the mediators. I'm not going into it, but I'm just referring you so that you can go into it. And there is a code of conduct is there. You are supposed to be neutral. You are supposed to be independent. You are not supposed to be interested in this matter which is before you, which is referred to you. For any reason, if the matter referred to the mediator, and if you know the party involved, or if you have any interest in that, you are supposed to inform the commission that, sorry, not before me, and I will not be able to take. So these are the regulations made there. Now, normally all the cases can be referred to the mediation, but there are certain categories and certain cases which the Act says the Commission shall not refer these matters for the mediation as prescribed. They say, the section says that as prescribed, following things will not be referred to the mediation. And what are they? Now there is under the rule, as I said, the rules are made, and the rule 4 says the matters not to be referred to mediation. The following matters shall not be referred to mediation, namely, the matters relating to proceedings in respect of medical negligence resulting in grievous injury or death. That means serious cases of medical negligence cannot be referred to medical mediation. Second thing is matters which relate to defaults or offenses for which application for compounding of offenses have been made by one or more parties. So even such category of complaints or disputes cannot be referred to mediation. The third category is cases involving serious and specific allegations of fraud, fabrication of documents, forgery, impersonation, and coercion. These sorts of complaints or disputes also will not be referred to mediation. And fourth category, cases relating to prosecution of criminal and non-compoundable offenses also cannot be referred. And the last category is cases which involve public interest or the interest of numerous consumers who are not parties before the commission. So public interest matters also, class action matters also cannot be referred to the mediation. So rule 4 under the mediation rules enumerates or lists 5 categories which cannot be referred to mediation. So this is something, even from your examination point of view, this is going to be a very important thing. We all know that, okay, there is a provision for mediation. Matters can be referred for mediation. What is important is, as we know, we always try to understand and learn the law by the exception it makes. So here also mediation chapter, if you have to understand, the first thing you must know that what are the matters which cannot be referred for mediation. And rule 4 under mediation rules says that these are the 5 categories, particularly medical negligence, then the fraud, fabrication, and all that thing, as I have said, you can refer to that. But this is going to be a very important thing that you must remember. What are the matters which cannot be referred for mediation? Now, having said that, are there going to be any fees for this? The question will come, because mediators are going to be paid. Who pays the fee? The law provides that the mediation fees will be fixed by the president of the commission. And it can refer from case to case. Because, the claim could be of 5 lakhs, 10 lakhs, 50 lakhs, or in crores. So maybe depending on the valuation of the claims, the president may decide the proportionate amount as a sort of a fee. And there is no bar, or there are no guidelines given as to what should be the basis, what should be the norm. And entire discretion of fixing the fee for the mediation is given to the president of the each commission. Who bears these fees? The law says that the fees shall be shared equally by the parties. So if there are 2 parties, complainant and opposite party, it will be 50-50. If there are complainant and 2 parties, then it will be 1/3, 1/3, 1/3. So like that. But the fees are to be shared equally by all the parties. Now there is another interesting aspect. When the fees are to be paid, they are to be paid immediately once the mediator is appointed. But these fees will not immediately go to the mediator. Mediator will get his fees only after closure of the mediation. And there again, there is an interesting provision. If the mediation succeeds, then he gets the full fee. And if the mediation fails, he gets only 50% of it. There is another issue and another provision. The mediation, if it is a successful mediation, the complainant who has paid the application fee, you know that when a complainant files a complaint in the consumer court, beyond a certain level, he pays the fee. However nominal it may be, it starts from 100 rupees and goes up to 7,500. But whatever that fee is paid by the complainant, he is entitled for the refund of that money if the mediation is successful. And if it is a failure, then of course the fee goes, and the mediator also gets only 50% of it. Whether it is a sensible provision or not, I will not comment now on it, be that as it may. But for your academic interest and from your examination point of view, the fee structure is like this: no fees prescribed. The complete power is given to the president of the commission. He will decide case to case basis, and it will be paid after the completion, as I said, and then whole thing is closed. Now there is another point what I would like to say is, and particularly I would like to impress upon all of you, and some of you are going to be the presidents of the district commissions, and many of you are going to be the members of the district commission and the state commission. I would request you, encourage the mediation as far as possible. Why? Because there are many advantages. There are really many advantages to the parties, to the judicial system, to everybody. And let's see what are the advantages what parties get when they go for the mediation. Mediation, as I told you, is a settlement. And one more thing I would like to impress upon you, that a mediator does not get involved into deciding who's right and who's wrong in the case. That is the job of the court. That is the job of the Consumer Commission, that yes, the opposite party is guilty of so and so, and then, okay, you award compensation. Mediator intervenes in the dispute and tries to see there is a possibility of amicable settlement, समझौता. समजूतदारपणे तोड काढणं, तोडगा ज्याला आपण म्हणतो, असं काही तोडगा काढता येईल का? Let us keep the issues aside. Who's right, who's wrong? Because if that is the thing, then the mediation will fail, bound to fail. So the issue that one has to see is how best the issue can be resolved, and that is what the mediators try to attempt. And what are the advantages? As I was saying, that you must encourage the mediation. It's a need of the hour. In fact, many of you may also recall very recently, even the Chief Justice of India, Dr. Dhananjay Chandrachud, he had said, mediate, not litigate. Because there are n number of advantages in that. First thing, if we can go for the mediation, it is going to reduce the load on the courts. In this case, on a consumer courts. We know the pendency in the consumer courts. I'm not going into statistics, but entire consumer courts machinery is bogged down with pending cases. A lot of pendency is there, the time it takes and all. So the first advantage that the mediation gives to you, if the mediation succeeds, is saving of time. Secondly, saving in the money for the parties. Thirdly, it curtails the litigation journey. Mind you, if there is a settlement with the help of the mediator is supposed to draw the consent terms. It is called a settlement agreement. That is drawn, both the parties sign it, and then the mediator is supposed to send this settlement agreement with a covering note in a sealed envelope to the commission which has referred the matter to the mediator. Now with this, the advantage is that since both the parties have agreed to the settlement, there is a huge possibility of the compliance also. Because without any coercion or pressure, or without any just court directing that you award this thing, both the parties were involved in the discussion for settlement. So whatever is possible and not possible, both the things have been explored by the parties, and then they come to terms. So it's a mutually acceptable solution is there. So there is a greater possibility of the compliance also. And since it's a final and binding and there is no appeal, except in the exceptional cases, there is no appeal. So if there is no appeal, again, there is no further litigation, there is no further cost. Yet one more benefit is that in a mediation, unlike in a judicial redressal system, in a judicial redressal system, there are limitations on the court. Whatever the things have come before the court with evidence and all, court has to only decide who's right and who's wrong. Rarely there is any possibility of a sort of a compromise or something out of box solutions at all. Mediation provides innovative solutions. Mediation provides out of box solutions. And it leads to something, a greater degree of satisfaction. It's a win-win situation. Nobody is lost because mediator does not decide that you are right and he is wrong. He only facilitates the discussion. And that is how the mediation is a preferred way of dispute resolution. And hence, as I was saying, that encourage as far as possible the mediation in a consumer commissions in the years to come. That will substantially reduce the load also on the consumer commissions, and it will give greater degree of satisfaction to the consumers as well as to the opposite parties. It will result in the speedy disposal of the complaints. And also there are other issues like parties. There's another important issue I would like to highlight. Unlike judicial process and the judicial proceedings, the proceedings before mediator in mediation are party-centric proceedings. Unlike in a judicial system where the advocates represent the parties and argue on behalf of the parties. Parties are not allowed to speak in the courts. If at all somebody spontaneously want to say something, the judges silence them that you have engaged the advocate, we will hear that. Rarely the judges allow the parties. Sometimes they do, but it's a rare thing. By rule, only the advocates are supposed to. In mediation being a party-centric thing, it is the parties who get the choice, the say that, hey, I want this solution to be like this, not like this. So the solutions can be molded and the parties have their say in this. So it's a greater degree of involvement of the parties themselves. Advocates can assist them. And this brings me to the another aspect of the mediation. What is the role of the advocates? If you ask me, frankly, they have a little role. Or I would say a little role. Because if I say little means no role. A little role. And that role is a backside thing. Not on the front burner, back burner. They have to only see that the mediator does not cross his limit and does not coerce or does not unduly influence the parties to settle the dispute. And once the dispute is getting settled on certain terms and conditions, the advocates have to see that the settlement terms are drafted properly, which will not give in future rise to another dispute. So there is a role for the advocates, but there is a limited role, nonetheless important role, and advocates should play that very nicely. Another tip that I would give it to the advocate, although it is not a matter of your examination and all, you need to know that when you appear before the mediation, you need to change your hat and you go into a different shoe. You go into a shoe of a party. You wear the hat as a mediator yourself. You are also assisting the mediator. And try to see that parties can amicably resolve this thing. In the courts, what we do, I get a brief and I say that my client is right, come what may. Here, you have to forget that position and you have to see whether amicable dispute resolution is possible. So this is an absolute change of role, which the advocates must remember. And they must see how best I can extend my full cooperation to the mediator and to the parties to resolve the dispute amicably. So there is a role for the advocates to play. There is a greater degree of role to the mediators to resolve the dispute for which they are trained. Even in this also, those advocates who are not trained but will be empaneled as mediators, it is a responsibility of the government and the commissions to extend them the training, because it's a communication skill. It's a matter of communication skill. And there are special skills in mediation or conciliation. So government will always organize such things also in Maharashtra. And those who will become the mediators, I mean, our advocates who will be taken on the mediators panels, they will have to also undergo this sort of a training, which will help them act as mediators in a better position. So this is largely, I would say, the mediation. What is mediation? Then what are the advantages we have seen? The fee structure I have told you, but I'm not going into the details of it for want of time, but read not only the section 74 to 81, read the regulations in particular, and read the rule 4 under mediation rules, which gives the exception to your matters to be referred. So what matters cannot be referred to mediation is something important. And with this, I think I have taken a lot of time on the mediation. There's a lot I can say more still, but for time being, I think I will conclude on mediation and then come to e-commerce rules. Now, e-commerce rules. For that, today we must know that we are living in the era of e-commerce. Thanks to pandemic, e-commerce suddenly erupted, and we were faced with a new market scenario, which was already emerging even pre-COVID, but it got accelerated, multiplied, and it has become a common thing now for any person, even including the senior citizens, even those who are not much literate also and all. They have become so much used to this e-commerce shopping, online shopping. And so much so, these typical e-commerce transactions, if we see, these are faceless transactions. Online shopping, faceless. It is contrary to what our typical traditional shopping as a consumer, that you and I go to the marketplace, see and feel the products, touch the product, talk to the seller, at times bargain also, and then we buy the product. Now, today, we are living in a society where I have this mobile. I just press a few buttons. I have certain apps. I want certain commodities. I go on Amazon. I go on a big basket. I go on this and that and all, and I order. I don't see whom I'm talking to because I don't talk. I just press the buttons. I see the product, only visual image, and I say, oh, I want this. The price is there. I press the button. Okay. It goes into my cart. 1, 2, 3, 4. And I say, okay, submit. I get the bill. I make a payment. My money is gone. And then the product is delivered. At times it's a cash on delivery. A little mercy to the consumers. And then I get a basket at home in less than perhaps 24 hours. Now there is a competition that, okay, we give in less than 8 hours. Then somebody says, I give less than 3 hours. Then somebody comes up and say, I give less than 2 hours. This competition is there, rat race is there. That is e-commerce. Faceless transactions. You don't know whose product it is. You don't know who's selling it. You don't know who's providing that platform called a e-commerce platform. All fine, so long as everything goes good. That I pay and I get what I want. But not that always it happens. In e-commerce transaction, there are a lot of risk. For the simple reason, it is different from your brick and mortar shopping. Like going into the shop, bargaining with a baniya, or going into the malls and seeing, feeling, touching, and then selecting the product. Nothing of the sort. We do it all on a mobile. So there is a greater risk. And that is the e-commerce thing. Fortunately, with changing time and changing trend, the parliament has also thought fit to protect the consumers from this very novel, unique shopping pattern emerging through the e-commerce. And for that, there is one single section, section 94 under the Consumer Protection Act, which talks a little about e-commerce. What does it say? It says, it's under chapter 8, last chapter, measures to prevent unfair trade practices in e-commerce, direct selling, etc. It says that for the purposes of preventing unfair trade practices in e-commerce and direct selling, and also to protect the interest and rights of the consumers, the central government may take such measures in the manner as may be prescribed. This is the section 94, which gives rise to the rules that have been framed under the Consumer Protection Act. There are specific rules called Consumer Protection E-Commerce Rules 2020. There are a lot. I think it is running into 1, 2, 3, 4, 5, and 6 pages. So it's a very sort of a comprehensive, I would say, guidelines for ensuring and protecting the interest of the consumers. Why it is so? In fact, if you remember, I just now read section 94 under the CPA. It talks about preventing the unfair trade practices in e-commerce. Why so? Because of its very nature. As I said, because you do not know whom you are dealing with. You do not know where your money is going. You do not know the product. So all invisible acts are there. And that is why there is, as I said, there is a greater risk in e-commerce marketing or e-commerce shopping. And that is why government thought it fit that there is a greater need, although there are a lot of conveniences for the consumer also. I sit at home and order anything and everything, and I get it. Fine. It saves a lot of my time. It helps me. But what happens if the things go wrong? And that is where we come into picture. And that is why the government has framed e-commerce rules. And for that purpose, what we need to see is they have defined also, if you see in the Consumer Protection Act, what is e-commerce? If you see what is e-commerce, section 2, subsection 16, e-commerce means buying or selling of goods or services, including digital products over the digital or electronic network. This is what is e-commerce. Now in e-commerce, they have further defined what is e-commerce entity, and that is defined under the rules. They have made two categories of the e-commerce entities, and that definition also you must know. These are two definitions under rule 3F and 3G. One is an inventory e-commerce entity. Now remember carefully what I read. Inventory e-commerce entity means an e-commerce entity which owns the inventory of goods or services and sells such goods or services directly to the consumers and shall include single brand retailer or multi-channel single brand retailers. What is important to remember is that the inventory e-commerce entity owns the goods or services and then they directly sell that to the end consumer. Ownership is there, product is there, and they are selling directly to the consumers. Second category of e-commerce entity is what is called as a marketplace e-commerce entity. What is marketplace e-commerce entity? It says it means an e-commerce entity which provides an information technology platform on a digital or electronic network to facilitate the transaction between the buyers and sellers. This is called a marketplace e-commerce entity. That means a party comes with a technology platform and it enables the buyers and sellers to come on the platform and transact their business. But in the meantime, the marketplace entity, that is the platform, e-platform we can call it, definitely benefits because he gets something out of that from the sellers who offer their products for that. That is the e-commerce marketplace entity. And earlier we have seen is the inventory e-commerce entity where they sell their own products. For example, if I give you Chroma, Tata's Chroma is a inventory e-commerce entity. Whereas if you see Ola, Uber, they are aggregators. They have the platform. They don't own the vehicles. The vehicles owners, they offer their services and they offer their vehicles for rides. And the consumers like you and me, we go on that Ola platform or Uber platform and I say, hey, I want to go from here to there. And then they have their own programming. Their algorithms are there. And then they tell you nicely, okay, the cab will come in another 5 minutes, 10 minutes or 7 minutes. And this is going to be the fare and all. So these are the marketplace e-commerce entities. So these rules make two categories for a different purpose. Now, what is more important is there is a third player in this, apart from second player. One is a e-commerce platform who allows them to come together. And then there is a seller on that. That is the one who's offering the product. Now the e-commerce rules give the duties of the e-commerce entities as well as the duties of the e-commerce sellers. Those who are the sellers on the platform, they have to abide with certain rules and regulations. Now in these rules, I'm not going into details because these are 6-7 pages. Please go through that carefully if you have to prepare for the exams, and even otherwise, as a consumer, you must know what are your rights. A lot of things are done in the interest and for the benefit of the consumers. But broadly, what I will touch is what these rules deal about. They deal with, number one, duties of e-commerce entities. Then they talk about liabilities of the marketplace e-commerce entities. And then they talk about duties of the sellers on the marketplace entity. Now, some of the things are very common. And what are the common things? The most common thing and the most important responsibility or the liability that is imposed on this e-commerce platform, be they inventory entity, or be they the marketplace e-commerce entity, or be they the sellers. Since all of them are invisible to you as a consumer, these rules make it mandatory for all of them to ensure that they display their identity, they first thing, they register themselves and they have the office in India. That is the first precondition. You may be Amazon, you may be any other foreign company and all that thing with an e-commerce platform, with all the latest technological innovations with you. No matter. You need to register, you need to have a branch in India which is accountable to Indian laws. And that is the Consumer Protection Act. They are also liable under the IT Act, that is the Information Technology Act. They are treated as the intermediaries. So there is another set of rules for the intermediaries also. They also act as an intermediary. But here Consumer Protection Act also covers and regulates their activities in order to protect the interests of the consumers. And to protect the interests of the consumers, what is most important is when the things go in a routine way, normal transaction, no issue. But what happens when the things go wrong? Where do the consumer goes? Because everything is in a thin air. It's on a mobile screen. Where do I lodge my complaint? And suppose if I lodge a complaint online and nothing happens, whom do I catch hold of? So these rules make it very clear that you shall have your office, you shall have your nodal officer who's responsible for grievance redressal. You will display your email ID, your mobile number, and all the things. So it's all made mandatory. Further, it says that you will generate the tickets for each complaint that you have received. And the complaint has to be acknowledged within 48 hours of the receipt of such complaint. These rules also give a timeline for this marketplace entity or the inventory entity, whatever you call it, as a basically the e-commerce players, I would say, that the dispute internally you have to resolve it within 30 days. Acknowledgement within 48 hours and dispute resolution internally within 30 days. Otherwise, then you have your consumer commissions and all that things where the consumers can come. So accountability, in short, I would say, has been established through these rules for these e-commerce players. And thereby, the interests of the consumers has been adequately protected, I would say. The care has been taken to see that the consumer interest is adequately protected. In fact, another step I would like to share with you what the government has done. Many of you may be aware that there is a system for lodging complaints of the consumers, and there is a National Consumer Helpline, NCH. So any consumer who has any grievance, you can lodge an online complaint, you can send SMS, you can send WhatsApp, you can send email to this NCH, National Consumer Helpline. It's a central government's machinery under Department of Consumer Affairs, where all the complaints get logged, and then they refer it to the parties against whom the complaint is lodged. Now, what government has gone a step further, they are trying to tell all these e-commerce players that you become our convergence partners, so that automatically when the complaint comes to NCH, National Consumer Helpline, it will be directly routed without any loss of time to the e-commerce players being the convergence partners. So there is no wastage of time. Immediately the moment you go into the NCH channel, the moment if he is a partner, then automatically complaint is straight away routed to that e-commerce player. It is not made mandatory as yet. Government is trying to persuade. It's a soft skill. It's still not, government is not still so harsh that you must. It is a sort of a consensus is being evolved with the industry that let every e-commerce player be the convergence partner. Time will come when all of them will join. Some of them, they still have a sort of a reluctance. They have certain reservations. The matters are going on at a discussion level at Government of India. But sooner or later, I'm confident that all e-commerce players will come on this NCH platform also as convergence partners. And then the dispute resolution can be perhaps simpler and speedier in the interest of the consumers. But in short, what I'm trying to tell you is that government has taken adequate care through these e-commerce rules to establish the accountability, establish the presence of these e-commerce players in India so that they don't run away, and try to resolve these disputes amicably through the internal grievance cell. And of course, if the internal grievance cell does not resolve the dispute to the satisfaction of the consumers, then of course he has the choice, he has the option to knock the door of the Consumer Commission. And then if he comes to the Consumer Commission, then also you have a further option of what we have just seen is a mediation. Instead of a small purchase, what I have made, the matter is about 5,000, 10,000, 15,000. Why wait for 2 years, 3 years, 4 years and all? So if such complaints come, I'm sure Consumer Commissions will find this as a appropriate case to be referred to mediation. And then these small claims can be easily tackled through mediation without creating much of a bitterness, ill feelings and all. Maybe perhaps there is a loss of some practice to the advocates, but I think this is going to be the scenario in sooner or later, that for small, simple things, why fight? Why go for that? Resolve it amicably. Coming back to mediation, there is also a provision that is proposed in the bill, that what is called as a pre-litigation mediation. And that pre-litigation mediation means if you want to file complaint in any court, before that, you should exhaust the possibility of dispute resolution through mediation or conciliation. I mean, since it's a mediation bill, it will call through mediation. And another provision in the mediation bill itself says that even conciliation will be treated as a mediation. So whether it is mediation or conciliation, both are alternative dispute resolution mechanism. They are really worthy of giving a try. And I say that that holds a lot of hopes for the distressed consumers, distressed litigants, not only consumers. The other side also is distressed many a time. They also suffer hardships. Okay, so when it comes to the dispute resolution within the framework of the Consumer Protection Act, I will say that while concluding, mediation is definitely a good provision, a welcome provision. Although in the initial remarks of mine, I said that looks contradictory, that The act itself says that our dispute redressal mechanism is supposed to resolve the disputes within 3 to 5 months, and then you are again providing another alternative of mediation. A question may be asked that can this mediation facility be misused for further delaying the matter, that I go back to mediation, then it is up to me whether to cooperate or not. And then I take some time, 3 months are passed there, and then I come back to this. It's possible. Another thing, what I would also, while passing, just make a mention about that. In mediation under the Consumer Protection Act, it is also possible for the part settlement. What is part settlement? Part settlement is, suppose in a given dispute, there are 5 issues involved. And out of that, both the parties agree on 2 or agree on 3 and do not agree on the remaining thing. Then what happens? Can it be said that, oh, the mediation has failed? No. If you can isolate these issues on which there is an agreement between the parties, this is called a part settlement. And the mediator is supposed to send a report to the commission saying that this is a case of a part settlement, issue 1 and 2 settled, issue 3, 4, 5 not settled. Then the Consumer Commission will, in its own way, adjudicate that matter for the final law. And whatever is settled, even it is a full settlement or part settlement, when the commission gets the report from the mediator with the settlement agreement, they pass the order taking that settlement agreement on the record, so that it becomes a enforceable order of the Consumer Commission. So it is binding. And largely, as I said, with slight exception, it is non-appealable because both the parties have agreed to perform in a particular way. So there is a question of being agreed against that. You yourself have put your signature with your own eyes open, own ears open, without any coercion, without any influence. So no appeal. So it's the best way of resolution. So I would say that more efforts should be directed towards dispute resolution through mediation. We need a lot of good mediators also for that. And if that happens, then, only genuine serious cases, we can leave it to the consumer commissions to adjudicate and decide, and take small claims, simple issues and all can be mutually resolved. And if we succeed in this sort of a scenario, then definitely Consumer Protection Act itself is going to succeed in achieving its object of a speedy, simple dispute resolution. Okay. So with this, I think I conclude. I once again thank BCMG office bearers for giving me this opportunity once again. It was my really pleasure, because when it comes to talking on consumer, it's my passion, as you know. I love it. I enjoy it. And to you all, those who are going to appear for the exams for selection as a president or as a members of the district commissions or the state commissions, I wish you all the best and do well. Thank you very much.
Respected Deshpande sir, thanks a lot for guiding us on the topic of provisions of mediation and e-commerce rule under Consumer Protection Act 2019. Your session was really an informative and incredible. Thank you, sir, for giving this opportunity to all the aspirants. And before concluding this session, I would like to express my sincere apology, as while giving you an introduction, my colleague, assistant advocate, suddenly thrown out of the meeting and she could not introduce you. So pardon us, sir.
No issue. Everybody knows me well.
Once again, thanks a lot, sir.
My
Thank
pleasure.
You.
My pleasure. I think Dr. Uday has to say something.
There is an announcement. Tomorrow evening, we will be having a lecture from Justice Taude, who is a president of the State Consumer Dispute Redressal Commission, and he will guide all the students on the topic how to prepare for this exam. खरं सांगायचं तर परीक्षार्थी आपण सगळे बनलेले आहात, त्यामुळे परीक्षेमध्ये आता कशा पद्धतीने पुढचे 10 दिवस वापरायचे आहेत हा त्यातला मुद्दा आहे. आणि ते 10 दिवसाची जी तयारी आहे ती तयारी कशी करायची या संदर्भामध्ये आपल्याला मार्गदर्शन उद्याच्याला मिळणार आहे. सो देअरफॉर उद्याच्या करताचे प्रश्न तयार करून ठेवा, कारण पेपर 1 ची तयारी कशी करायची, पेपर 2 ची तयारी कशी करायची, हे दोन्ही मुद्दे आपल्याला जस्टिस तावडे उद्याच्या मार्गदर्शन करणार आहेत. आणि ऍज युजल शिरीष देशपांडे साहेबांनी आपल्याला वेगवेगळे पैलू सगळे समजावून सांगितलेले आहेत आणि त्याच्याकरता आमच्या सगळ्यांच्या वतीनं वी आर रिअली ग्रेटफुल. एकाने विचारलेलं होतं की एमसीक्यूचं काय, तर देशपांडे साहेबांनी आम्हाला किमान 10 एमसीक्यू याच्यावरचे द्यावेत तयार करून. दोज वी विल शेअर विथ द स्टुडंट्स. गो बॅक, लेट अस गो बॅक टू ऍडव्होकेट सुजाता जाधव. थँक्यू.
Thank you.
Thank you. With the permission of coordinator, our chief coordinator, Advocate Dr. Uday Wadunjikar sir, I would like to conclude this session for today. Host, please kindly over the meeting.